This is Julian Prieto, principal lawyer at Just Done Law, real estate law firm, offering virtual real estate law services across Ontario. Here are some frequently asked questions that you may get as a real estate professional and that it may be useful to know. These are just tips and general rules of thumb and do not represent legal advice. Every case is different. The first question we often get from our clients is whether they have to pay land transfer tax when somebody's being added to the title of the home. In Ontario, when somebody buys or sells a home, the purchaser will pay the provincial land transfer tax, which is based on the value of the home. But when a title transfer is done and no money is exchanged, the question is whether the tax is payable. And it turns out that in many cases it can be. The government can consider it subject to land transfer tax. So if there's still a mortgage on the home, then land transfer tax will be payable based on the value of the home, even if no money exchanges hands when the transfer is made. The one exception to that is among spouses who are entitled to add or remove somebody from title without paying land transfer tax. The second commonly asked question that we often get is whether when you are buying a property as a spouse and one of them is your partner is a first-time home buyer, but you're not, let's say, whether you're entitled to the first-time home buyer rebate. So in Ontario, if you are buying a home for the first time, you're entitled to up to $4,000 of a provincial land transfer tax rebate and up to $4,000 of a municipal land transfer tax rebate if you're purchasing a home in the city of Toronto. If you're married and your spouse has owned a home anywhere in the world at any point when you were married, then neither of you qualify for the rebate. But if that home was sold prior to the date of marriage, then both of you qualify for the first-time home rebate. The third commonly asked question that we often get is, what happens if you default on your mortgage? Obviously, when you obtain a mortgage loan from a bank or a lender, the deal is that you have to make your payments on time. Otherwise, the bank will have the right to take your home. And the most common form that takes is the power of sale. Generally speaking, the bank will give you 15 days for you to put your loan in order. And if you still haven't paid, there'll be another 35 days that you can do that. But if you still don't do that, the lender will be able to power of sale, meaning that they can sell the property to somebody else without even having taken possession of the home. They could also move in for a foreclosure where they do actually take possession of the home or ask court for an order. But the fastest and the least expensive route from the perspective of the lender is to do a power of sale. The fourth commonly asked question that we get is whether you can register a second mortgage without informing your first lender. And that will depend on the contract that you have with your first lender. Generally, first lenders are hesitant to allow for second mortgages. And if that is the case, and the first lender finds out that you put a second mortgage on the home without their consent, then they would be able to claim that the loan is fully payable, and if you don't pay them, they can do a power of sale. So that's something to be very careful of, and to make sure that you understand what the contract is with your first lender before going into a second mortgage loan. The next question that we often get is what the exceptions are to the foreign home buyers ban. In Canada, federal legislation passed that foreigners are not allowed to purchase residential property. The most common exceptions are if your spouse is a Canadian citizen or a permanent resident, if you have a work permit that is valid for 183 days, if you're inheriting a property, if somebody dies, you can still inherit that property even if you're a foreigner. And if you're on a student permit and you have declared your taxes and the property that you're purchasing is under $500,000, then you can still buy up to one property. And of course, if you're buying a property that is not residential, but rather commercial, there's no restrictions and you can still buy them. Even if you are allowed to buy as a foreigner under federal prohibitions, you may still have to pay the Ontario speculation tax, which is up to 25%. In some cases, you're eligible to pay the tax and then apply for a rebate once you become a permanent resident. Next commonly asked question is, what happens if I die without a will? How will my property be distributed after? And it turns out there are two types of property. The ones that you jointly own with somebody, such as joint bank accounts or homes where you are the joint owner. In those cases, the property will pass to the other joint owner automatically after the death of the first. In the house, the real estate lawyer will have to register a survivorship application, but that is quite easy and quite inexpensive. The second type of property are the ones where you're not jointly owned, and those will pass to your estate. And your estate will be distributed according to some generally common sense rules called intestate rules. And in Ontario, these are that your spouse will get first pick, so to say. They are entitled to the first $350,000 of your estate, and the remaining part of the estate will be distributed among your children. If there's no children, then it will go to your parents, and so on, according to how closely you are related to other people. Eventually, if you have absolutely no relatives whatsoever, the property would pass to the provincial government. But of course, if you have particular plans for what to do with your estate that differ from those set rules, set interstate rules, then you may want to draft a will. The next commonly asked question that we get is about common law marriage or common law relationships. Let's say that you live with your partner, your boyfriend or your girlfriend over a long period of time, let's say for 5 years. The question is, are you entitled to claim part of the house even if you're not married? And the answer is no. The rules are different in different provinces, but in Ontario, there are no common law property right rules. Nonetheless, you may have to contribute spousal support or be entitled to receive spousal support depending on the length of time that you live with somebody. The next commonly asked question is, how is the property divided after a divorce? And the rule of thumb is that there's three types of property. There's a matrimonial home where you live during the marriage. That will be split in half, no matter who owned it prior to the marriage. The other types are properties that you bought during the marriage. Those are also split in half. The third is the type of properties where one of the parties owned it before the marriage. The appreciation, the increase in value of those properties will be split in half, but that property will be returned to the original owner. If you inherited something, that will remain yours, and if you received any insurance policy, that will remain yours, even if you were married. You do not have to share those. So there you go. Those are some commonly asked questions. I hope that they have been useful to you. And if you have any further questions and would like to get in touch with us, please do call us or send us an email. We'll be very happy to assist in your real estate matters or in your matters that are closely related to real estate.